Hi, Kamu. Hello?
Yes, I can hear you though. Can you hear me?
Oh, you can hear me? Okay.
Yes.
Okay, that's
letting
fine.
everyone
So
in.
I'll be using my phone for audio. So this is the
Okay.
one that was got to the Faith Tabernacle. I don't know I don't know how to change the logo. Let's leave it. We're using this for Zoom for church. Dr Obed.
Yes, Barabi.
How are you?
Man, doesn't have to complain. Can you hear me?
Oh, yeah, but you're muffled a bit. Kamu, can you hear Dr. Mphofu?
Can you hear me, Barabi?
Yeah, I can hear you now.
Yeah, okay. All right, thank you.
Yeah, let me just stop my video and try to increase my where's the sound here?
Hi, Dr. Bida. We are ready to start.
Yes, Kamu, you want us to start?
Yes, sir.
Okay, let me just sorry with that. Tell me if you can hear me.
Yes, we can hear you.
Oh, you can hear me. Just good evening, colleagues, and my video is off. Good evening, colleagues, and welcome once more to our weekly webinars hosted by ourselves at Clinics Health Group. It's a pleasure to welcome you every week as we participate in this program weekly. And this evening we're excited also to have one of our colleagues who's, he's got a dual qualifications, a medical doctor and also a lawyer by training at the same time. So it's in exciting times. And we are glad that we're able to get Dr. Mphofu to join us this evening. We should also be noted that these webinars are CPD accredited, and so we request that you always, as usual, give us your details when you register for these webinars so that we are able to help you to get CPD points. These are for all health professionals registered with either the Health Professions Council of South Africa or the South African Nursing Council or the Pharmacy Council of South Africa. Well, sometimes also may even have colleagues from the Allied Health Professionals Council who are joining us. But by and large, it's all these colleagues who are healthcare practitioners from across the disciplines in healthcare management. And so we at Clinics are quite excited to be able to share these thoughts with you as we get leaders, experts in their own fields, in various fields, either in the medical field or the nursing or pharmacy areas, pharmaceutical industries. And so this evening we are excited to have Dr. Obed Mphofu will be speaking to us on the medical practice, ethics, and the medico-legal aspect of healthcare. Dr. Mphofu is a colleague who's a specialist in occupational health medicine and also admitted advocate of the High Court in our country. He is the former head of health at Sasol Group and consultant in occupational medicine at Dr. George Mukhari Academic Hospital. He has also led the COVID-19 project at the same hospital, Dr. George Mukhari, based out there in Baragua, and also attached to the Spokane University of Health Sciences. He has quite a number of qualifications. He's got an MSHB from Medusa, which is now called Spokane Medical University of Health Sciences. Spokane University of Health Sciences, sorry. And also got an advanced diploma in occupational health from First State University, obtained in 2002 and 3, and Masters in Occupational and Environmental Health from the University of KwaZulu-Natal, quite in diverse areas where he qualified, and also an LLB from the University of South Africa in 2012, and an MBA from the University of South Africa, UNISA, in 2016. And he's got also a law degree in corporate law. I mean, he's busy currently studying LLM corporate law. And so, Dr. Mphofu, we are quite excited to have you this evening. It's been, we've been trying to juggle our dates to make sure that you are able to join us this evening. And it's quite exciting that you're with us this evening. And so welcome and to speak to colleagues, and quite a number of them, quite a high number that you're having tonight also, that you are able to speak to us. Thank you very much.
Thank you very much, Dr. Bila. Maybe I should start by saying that I'm honored to see this number of participants on the web discussion or the webinar that we have. Previously, I've done a lot of discussion on the webinar in different countries in the Southern Africa, and that is the last time I saw these numbers. But anyway, colleagues, let's not waste time. Let's go to the slides. Dr. Bila has introduced me. My approach is just to make sure that I simplify things, which I don't want to make things complicated. And then I just want to put the first slide as the presentation overview. And then, if I think we will answer question at the end, but I would like to make it as practical as possible. But, and also to make it, to create a framework in our minds, how this profession is and is governed and how it's structured.
Maybe if you can make a slide presentation.
Okay.
Yeah.
Yes. Can you see the slide?
Make it a slide presentation. Slideshow. If you
can't see
from beginning on your left hand side.
Okay. Can you see the slide?
Yeah, if you go to the top left-hand corner.
Yes, can you see that?
Yeah.
Okay. I'm saying I'm going to start with this slide. Can you see this one?
Sure.
Can you see this one? the slideshow? Can you see the slide?
Yes, we can see it.
You can see it. Okay, let me use. Okay, yeah. Can you see the overview of the presentation on slide, the following slide?
Yes, we can see that.
Okay, yes. I want to simplify this presentation by, giving you an overview. The overview will be introduction and challenges in the medical profession in South Africa. As you know, the current moment, we've got quite a lot of challenges. And I'll also give you a legal framework, governance and structure of the medical profession in South Africa. And the next slides the following slides will be on the duties and ethics within the profession. The last one that, one will always appreciate if it's a very high interactive session is the medical malpractices that we have. On the next slide, I'll just highlight the challenges that we have, as an introduction, but I would like to highlight the following that is very, very important. We've got quite a number of, acts that are the touch points when it comes to medical profession. But what is important is that the profession is regulated by statute. When I say it's regulated by statute, I mean that, there's a statute, the profession is governed by statute in South Africa. And the statute that governs the health profession in South Africa is Health Professional Act. Health Professions Act governs, the medical profession in South Africa. But again, when this act governs the health professions by, establishing the Health Professional Council. Therefore, the Health Professional Council, together with the Minister of Health, in terms of Section 3 and Section 4, and with their subsection of the Health Professional Council, are the creature of statute, are the creature of the Health Profession Council of South Africa, Health Profession Act of South Africa. I want to specify here that we need to make sure that we understand that, the Health Professional Council is a creature of the Health Profession Act of South Africa, Act number 56 of 1974. It is very, very important because this council and the boards that, and the boards of the council are the provision from the Health Professions Act. The profession is subjected to several challenges. One, you hear it from the junior doctors and the senior doctors, because, we are not used to, the past 20 years, we are not used to this, internal disciplinary hearing being held before the Health Professional Council, and then the litigations, now it's becoming more frequent. Some people are blaming it on the road accident fund, blockage or, seizing, and a lot of lawyers are moving towards, the hospital. Complaints to the hospitals, complaints to the Office of Health Standards, medical aid, forensic investigation. And these are the things that are engulfing, especially in the private practice. A lot of our colleagues are being subjected to quite a lot of these challenges that are there. And one thing that I've realized, because I've seen it with my colleagues approaching me, not knowing what to do, we will highlight, because one of the most important things to do for all of us is to understand the structure of the health, the medical, how it functions, so that we get used to,
sorry, Doc.
Yes.
If you can maybe double click on your slides because they're not moving.
They're not moving. Okay.
Yes.
I'm just going to the next. It's still the same slide. Can I go to the next one?
Yes. You can just click on there on the next slide that you're on.
Okay. Yes. Yes. As I said in the introduction,
It's still not moving, Doc.
It's still not moving.
Yes. Try using your pointer or your mouse to move them.
Okay, let me use the mouse.
Double click on number 2, on slide number 2.
Okay, let me go back. Number 2.
Yes.
Can you see that?
It's still not moving.
It's still not moving. Let me just.
Yes, go to slideshow again. Let's try slideshow again.
Let me just get it.
Please try moving it.
Okay, let me. Can you see anything? I'm clicking on it.
Yes, we can see it. Just try going to the next slide.
Okay, this we are. I think we are far, with the slide. Can you see
now it's moving? Yes, it's moving.
Yes.
You can go to the current slide you were presenting on. It's fine now.
Yeah, now they're moving. They're moving. Yeah.
Okay.
So I think I think just click on the arrow buttons there from 2 to 15 or so. If you keep on moving to the right. Yeah, maybe. Yeah. Yeah, you just go back to the, that's fine. It's great now. Now we can go.
No
problem.
Sure. Okay,
thank you,
next
Doc.
slide. Hello?
Yes, you may continue. Thank you, Doc.
All right.
Yeah, you're on the right slide, Doc. You're on slide 4. Yeah,
yes.
Yeah, you can speak. Right. You are on slide 4, that's fine. Yeah.
Yes. Yes, colleagues, I was just addressing the question that the challenges that we have as health professionals in South Africa, and the body that governs us. And I've highlighted that the body that governs us is actually a creature of statute. It has been established in terms of Section 2 of the Health Profession Act, Act 56 of 1974. I just want us to realize, the act that is really, governing us. Then I've highlighted also these challenges that we have. And these challenges are increasing at alarming rate and threatening to some extent the existence of healthcare services in South Africa. And I've seen this pattern since 2014, of threat, especially the malpractices and the legal litigation that is encroaching in our space. And is encroaching in a very adversarial, type of approach. And it's very, very difficult for some of our colleagues to handle, such approaches when it comes to their practices or in your hospital. There are a number of institutions, hospitals that, I think you have seen that the MECs and the Minister of Health was talking about the running cost of medical legal cases or litigation. That they are not even estimated. They are running into billions of rands. If you look at the different provinces from Gauteng to Eastern Cape. But again, this has an impact, obviously, on the service delivery because, on the new year, the accruals in the hospitals are at a very, very high, cost, and therefore it compromised the budget of a particular hospital, whether it's an academic hospital or a district, but again, at the end of the day, I'm saying that the legal case and litigation a cost that is running to billion do compromise the services that we give to the people. But it doesn't only compromise that, it has an impact on how we run our game, how we run the health system inside, whether it's a public or a private institution. And medical practitioner, we colleagues as medical professionals, we're in a potential risk as providers of healthcare to the clients. And we have seen this pattern increasing in different specialty. But again, the impact that it has, it's on the health profession as a whole. The next one, I just give a legal framework or a governance framework that we have. Professions, this profession is subjected to several legislation or acts. We've got, I divided them into the pre-94 and the post-94. The pre-94, what was the most big governance body that used to direct and control the medical profession? It was the ethics that we have. Let me just qualify it and say the medical ethics, because there's other ethics that are there that are not next to medical ethics, and also the common law that was there. Those are where the most important governance structures that we used to have pre-94 that governs the health profession in South Africa. But now, post-1994, there was a lot of fundamental and continuous changes, both technical or in governance. And these changes that we are seeing in the legislation affect us. And some of them are to some extent palpable. I mean, if you look at some of the legislation that we introduced, new ones that has a touch point with the medical profession, such as POPI Act and PAI, and those, it has an impact on how we do the work, how we execute, or service our people in South Africa. But post-1994, based on the Constitution of the Republic of South Africa, remember you've got Section 12 as 2, that is very, very important. Again, it's about the choice, and also it has an impact on one of the ethics principles that we have, autonomy, that you will see down the line as the presentation goes forward. And then Section 14, again, is very, very important because it's all about privacy that we have. And I want to emphasize, the Bill of Rights, because it's an umbrella that, we fit in all these acts, fit from the umbrella of the Constitution of the Republic of South Africa. And the Bill of Rights is a fundamental, Bill of Rights that we have in South Africa. And the next one that we have that has an impact, but it's an executionary, type of act, is the National Health Act, the establishment of systems, the district system, the tertiary hospital, the clinics, and the national. This National Health Act has an impact on practitioners, whether you're a nursing practitioner, pharmacy practitioner, or especially and a medical practitioner, because how it's structured and how it dictates in some provision towards the medical profession. Under the next one is the Medical Schemes Act of 2008, and this is its amendment. This act has been amended, and also there's a statutory body that functions within this this legislation in terms of the CMS, the Council of Medical Schemes, that is that exists with Dr. Sipho Kabani being there with it. But what is important again, remember the business of the medical schemes is the act governs the business of the medical schemes. It's short and dry to describe it, and you will realize when we talk about the last one in terms of the Health Professional Council Act, it has a very focus on the profession, how it governs it, from whether it's strategic to operational level, how is it structured. But when it comes to the medical schemes, it's a business. Let me just leave it straight there and say it's the business of the medical schemes that is controlled there. The Competition Act, why I want to mention the Competition Act. Competition Act has had an impact on, say, a certain regulation that we previously had. You will remember the National Health pricing list that we had, and then recently, I think some of the guys who are aware of what is happening in terms of some ethics that we had, ethical guidelines we had in touting, and that what the Competition Commissioner has said about it. The Nursing Act, the nursing also is part of the touch point. We can't run away. We are part and parcel of the human resources in order to give service delivery. I've heard a lot of people saying that the systems in the state, in the public service, have a lot of challenges that are there. I do agree to some extent, but I always say in terms of the human resources, South Africa still have one of the most competent and strong based on, colleagues that we have, esteemed colleagues that we have in the profession, who delivers the services irrespective of the level of, infrastructure or levels that we have. But again, I just want to emphasize the Pharmacy Council. The pharmacy is very, very important. And also I added SAPRA. I think during COVID has shown us a lot of limitation and strength in our system. And also it talks to, the issue of ethics that we have during. It was more pronounced in certain areas, and it's very, very important for us to mention that, during COVID, we've seen that. And also SAPRA came in as a body in order to help, but again, there were a lot of changes based on, the time that we had that time. The PAI is Promotion of Access to Information Act, but this one is very, very important when somebody wants to conduct any action or even a litigation. Where do you get that information? In the public space, how do you get it? From the private, what are the requirements for you to get, that information? And the POPI is a recent one. There were quite a lot of, the promotion of protection of personal information act that was recently. We have seen, subs being, wrapped around, in the incident that happened around Krugersdorp. But again, it's a very important thing because it do affect us, especially the PAI and the POPI when it comes to inform, concern, and other, information that we can, give to third parties and other people. And again, those third parties might include even the medical aids and, other people from the society. But fundamentally, again, there's an interlink. There's a lot of touch points in this act. And this list I've given you is not exhaustive. There's additional acts that do have some touch points with the health profession. And it's very, very important for us to understand. Sometimes some of the provision, you have to read them in conjunction with some of the acts. Is very, very important. But again, fundamentally and central to the governance and the structure of the medical profession is the Health Profession Act of 1974. That is the main focus, because this act is the one that governs, is the one that controls the profession in conjunction with the Minister of Health, as provided in the two acts, Section 3 and Section 4. The emphasis is central to the act. I said that in controlling the profession in South Africa. And HPCSA is a product of the act. It is only the council that it only made a provision, provision of the council and the boards, and each board is, that is what the act does. And then what does the council do? Is the primary controlling body of the medical profession. I wanted to put these 4 points that are very, very important. The supreme statutory regulating body, that is whether, is a custom moron of the medical profession, the guiding of prestige, status, dignity of the profession in the public interest. This was highlighted, especially the point that is a custom moron of the medical profession in the case, the case in the previous dispensation of Riave. This was the president of South African Medical Dental Council. And this common law decision of the High Court is still applicable up to date. It has not changed at all. But these 4 points emphasize that the Health Professional Act and the council it established together with the board are central in regulating the medical profession in South Africa. And they are the supreme statutory regulatory body. And they are the guardian of the prestige, the status, and the dignity of the profession. It's very, very important to emphasize this, because sometimes we do lose it when it comes to when our colleagues have a lot of challenges. They do forget that this is the central area of control in terms of our profession. The next one. as I say, is just regurgitating, some of the things that I've mentioned. Section 2 is the one that gives rise to, that is the Section 2 of the Health Profession Act. It gives rise to, or it establishes the Health Profession Council. And what does, the health profession, what is the responsibility or the controlling effect of the Health Professional Council? It's responsible for guiding the profession and protecting the public or the society. But now the question is that how does it do that? How does it do that? We will address it on the next slide. So in Section 3 of the Health Profession Act, it sets out the object of the council. In 4, the powers of the council, of the Health Professional Council. In 5, the composition of the Health Professional Council. Why I'm giving you this is because I need our colleagues to understand, how power is derived, how power flows from, from the Act, and the council, which is a body that is provided for the execution of the, of the controlling effect and protecting of the public from the health profession, from the Act. Again, the boards of the council are created by statute, because I would like you to grab this from Section 2 to Section 5. It talks a lot about the council. The council, Section 2 of the Health Profession Act talks about the creation or the establishment of the Health Profession Council and the board. And then the Section 3 of the same Act talks to the object or the objectives of the Health Professional Council as established by the Act. And Section 4 talks about the powers or the general powers of the Health Professional Council. And then the last, that is Section 5, talks about the composition, or how the council is composed, from the Act. It provides for that. But now this one, because I pick some of the most relevant in terms of governance, some of the relevant provisions that are very, very important. I think some of colleagues would like to understand, how the body operates, because it's how it governs. Ultimately, it works towards governing, or it works to govern the medical professions as we have it. And again, it provides, that is the council, the board of the council created by it provides control. Let's take, for instance, what we have as the MDB board, that is the medical and dental board. It provides control over education, training, and registration of the health. This is very, very important. It applies to those who are registered in terms of the Health Professions Act of Act 56 of 1974. I just want to state that it's very, very important. It provides control over education, training, and registration for the practice health professional. What it means is that you cannot practice as a health professional in South Africa, or legally practice as a health professional now in South Africa, if you are not registered per provision of the Health Profession Council or the Health Professions Act, Act 56 of 1974. It provides for the general powers of the professional board. That is, remember the HPCC is a 12 plus 1, or is still 12, professional boards that are there. And those boards govern different areas of our profession. But again, for today, I will emphasize, I will, granulate a lot on the Medical and Dental Council. Another thing, it provides for removal of any person from the register, or restore that person to the register, or suspend a registered person from practicing his or her own profession, pending the institution of the formal inquiry in terms of Section 41 of the Act, that is the Health Profession Act that we have. Another thing that is very important, I think I should have put it next to the one of continued control of education, training, and registration, is appoint examiners and moderators, conduct examinations, and grant certification. That competency is provided by the provision that is the responsibility, that is, those are the powers of the councils, of the council boards that we have in Health Profession Council. It approved training schools subject to prescribed rules. Again, it's very, very important. And these are loaded provisions that we have. And sometimes we do know how the system operates, but now we need to granulate and understand some of the key provisions that are provided by the Health Professions Council Act that we have. Section 15B2, it provides any decision of the professional body relating to the matter falling entirely within its ambit shall not be subjected or subject to the ratification by the council. These are how this establishments are functioning, because that is very, very important for us to understand as health professionals as we move forward how the council operate, how the boards operate, and below the boards, obviously, there's a creation of committees that function for operational matters that are brought to the council. Next one, I just gave the example. This is an example of, in terms of the disciplinary hearing, section 41 and other sections that are there. The council have a committee of prelim, that deals with the case and refer them to, I said below, professional conduct committee that is there. And one of the things why I want to emphasize, and I want the colleagues to understand, I've seen our colleagues in this, going through this and not having understanding, because sometimes it's very, very important to have the understanding so that one should not panic and ultimately it might lead to a wrong decision. But again, it's important for us to understand how these bodies or the committees is created. Obviously, some of these committees are creatures of the board, and they can be creatures of the council per se. But what is important, I want to highlight these committees, and these committees are provided for by the boards that are there. And it's important that some of them will be just ad hoc committees that are created in order to address issue or some policy issue that are big challenging or that are just suddenly pops up, in the Health Profession Council. You've got the professional committee that sits there, and this professional committee, when it conducts hearing, it adheres to what South Africa, adversarial, legal system, that is there. It follows, those procedures that are there is very, very important. And sometimes I know it can create a lot of fear, especially with our colleagues. But again, if they go through and understand how this governance in terms of these committees work, it will create a much more easier situation or environment for them to undergo some of the things. And then the appeal committees that are there. But again, after all this, you have undergone this, you can even take it for a review at a high court, or you can take it for an appeal. But again, remember what is critical, the HPCSA, that is the committees, they've got also the appeals committee that also deals with this. But again, this is a structure in terms of the disciplinary hearing that, okay, and I want colleagues to comprehend it, because it's very, very important for us to understand, because that is where, there's a lot of the talking, and discussion around the ethics, the professional conduct, and sometimes, some malpractices, will be highlighted that, were addressed at the court. And again, there's a regulation that was very important that was established in terms of regulation 3.1, the ombudsman who went and do mediation. And that is very, very important. Again, in terms of, numbers of case law or cases that can confront the council, and with the capacity, it might be challenging. And I do believe the mediation was a proper channel or the proper process to undergo so that, you know, some of the minor cases can be addressed there. Majority of cases subjected to hearing are mainly on the question of ethics and professional conduct, with the exception of medical litigation, which may go to the court, whether criminal or civil. However, it comes back to the HPCSA or to the hearing as either an ethical or a professional conduct. If a person has committed, or a health professional has committed a criminal offense, obviously after the criminality, the Criminal Procedures Act or criminal procedure, that after it will go back to the medical council, because it's the membership, and then again, it's important. Its focus is on guiding the profession and also protecting the public. And also, it is very, very important to say that, you know, most of those cases will ultimately go back and, you know, be dealt with at the HPCSA. Then I want to go to the medical I put it as an ethics. And I've realized one thing that, you know, I always say, you know, the medical ethics is an applied ethics. And one of the questions some of my colleagues ask me is that, do you think medical ethics or ethics, bioethics, let me not say ethics, let me qualify it, is it a living guideline, or is it a static document? I said to them, you know, ethics also move with time. You know, if you look at our societal changes and the fast-paced changes that are happening in South Africa, it's not only exclusively in South Africa, across the globe, that is across the world. Again, there's a lot of changes, and those changes as a touch point on those living documents, that is the ethics that are provided, the guidelines that are provided by the Health Professional Council. At the present moment, I've seen that 17 booklets of ethical guidelines to the profession. And it's very, very important for some of the colleagues, when you have time, to go through some of the issues that are really confronting you. You will be able to trace some of the ethical, you know, challenges that will challenge you. Then the next one is that these ethics are not in isolation. They come from, medical professionals has duties. And the question I always ask, to whom do we owe those duties? We owe duties to patients. This is more pronounced. And in terms of the ethics, then you will see the fundamental values that underpin the ethics, you know, in terms of beneficiation, malfeasance, autonomy, and justice, resolve around this, you know, the duty that we owe to the patient. And this is very fundamental. It's very, very important for one to unpack it. But in unpacking it, it's not only the conduct that we have, it also at the core phase in management and treatment and in attendance of it. It's very, very important for us to remember that. And a lot of our ethics granulate around it. We can have some of the high-level ethics, such as what is that, branding and all this that we have. But when you talk about medical ethics, and especially some of the clinicians will call them clinical ethics, they are focused where they're taking the task, that is where at the cold face to our patients. But again, these ethics are not in isolation. I always say that the stakeholders that are involved, and these stakeholders are one, your colleagues. It's important we owe duties to our own colleagues. We need to work in harmony. We need not to cast aspersions on our colleagues. I know sometimes it does happen, you know, when people do that, but again, I want to remind our colleagues, again, in order to deliver the services we invested, we should not cast aspersion on other colleagues. We should create harmony with other colleagues so that we can create an environment of service delivery that we have. Then we have a duty to ourselves. I mean, if we have to avoid issues like substance abuse. We have to make sure that we are catered for when it comes to, if we are having challenges, are attended to, and we report. Even reporting ourselves to the council is very, very important. And this, the duty to ourselves, when you look at it, has an impact on how you treat the patient ultimately. Everything, again, it goes up to the patient. We have the duties to colleague, to work with them in harmony. Therefore, it impacts on the service delivery or the quality of the service delivery or what we deliver to the patient. And it's very, very important. We've got the duty to the society. It's very, very important. And again, we have a lot of discussion around what about duties to the society. We've got some of our colleagues who are sitting in boards. We've got our colleagues who are involved in health policies committee. And again, I want them to realize that, we've got this duty that is there as health professional, the duty to society. And we've got the duty to the profession. I'm sorry, colleagues, I said to professional, but we've got a duty to the profession because it's based on trust and is based on, the performance that we have, we execute wholeheartedly, and our commitment and compassions that we have towards the patient, and also, how we treat our colleagues, and also duty to ourselves, the society, and to the profession. The next one is just highlighting those foundational values that we have, the benefits to the patient. And if you look at it, I think below I just put the ethical rule 23 and 27 of the Health Professions Council. If you look at it, it revolves around this foundational value. There are others that are, following this one. The benefit to the patient, beneficiaries, null malfeasance. It's very, very important. It's exactly when you approach it. The intention is so simple. The intention is to benefit the patient, to provide the patient with the help or with the treatment or management which the patient deserves. The null malfeasance is very, very do not do harm. And it's very, very important. It's very subtle couching this. When we say do not do harm, we say, oh, okay, if a surgeon comes and the patient is a surgical something and it's not an emergency, and the patients have not signed, the surgeon can cut, it's not like that. It's important, again, because if you don't obtain that informed consent, that amounts to, malfeasance, because at the ultimate end, it will cause harm, and harm to body and integrity of the patient. And again, we talk about harm the body and the integrity and the freedom also to choose. These terms, they are relating to the Bill of Rights, that section 12.2 that we have. It's very, very important. This is why I'm saying some of the things, we derive them from the umbrella that we have. Then we've got the autonomy. This is very central. And again, it's very important because the practice of medicine or the practice of medical profession in the past was presumed to be centered around the paternalistic. The doctor knows it all, knows what is best. Again, this principle, autonomy, is fundamental and is very, very central to a lot of ethics foundation, of ethics guidelines that we have at the HPCSA. And the last one is justice. Then this other watching list, the colleagues can go through them: integrity, truthfulness. Again, it's about the conduct of our colleagues, whether it's within the work area, even outside, because it's very, very important. The truthfulness, the confidentiality, the compassion, the tolerance that we should have. Next one. Then when you're confronted with, with a patient, there's a lot of all those ethical guidelines or ethics that, might pop up and you might even think about them. And, in ethical decision making, there's quite a, some concept that were introduced in order for you to gauge, in terms of your performance of the work that you are doing or service delivery that you have. And again, one of the things that is based on the consequences of the conduct. If the results are good, are beneficial, then it means that what you are doing it's within the ethics, because at the end of the day, it goes back to your foundational ethical values that we have is beneficiation. You know, if you have benefited the patient, ultimately, then it was ethical. And the second one is the utilitarian principle, that the greater good of the society. And it's very, very important, you know, in terms of those who work at a high level, strategic level, and in terms of budgets and where to allocate budgets. Because at the low end, where they take a hit the tar, it's all about the patient and the quality of the patient outcome that we have. But at a high level, again, sometimes you need to rationalize the resources that are there in the health that are provided for health. And then, you know, you might need to, let's say, one wants to do a stand on 110 patient, 110 years patient, compared to buying maybe vaccines for a number of people. Again, the utilitarian principle will apply. You know, the greater good in society, how many people will benefit. But again, this is subject to, because every individual has rights. Again, if you take it back to the Constitution, then again, it might be, you might have competing rights that are there. But again, in terms of the ethics, you know, this concept help in the decision making, and then those who are found themselves in those levels will have to make those decisions. And the last one is deontological. This is duty-based, you know, what you do and the outcome, and that's it, you know. And it's different from the consequences, the one that is focused on the consequences, and the one that is focused on the utilitarian principle. I wanted to colleagues to realize that, because when you are consulting patients, when you are dispensing, when you are also with patients in the ward, these are the things that are very important. But again, what is interesting, that interface, the intersection, the stakeholders that are involved in the management of the patient, that include nurses, doctors, and it's very, very important. I want to highlight something that is, and I've seen that happening several times. You look at, you know, when you have a case, as you know, some lawyers have brought papers. You look at the papers, you look at the doctor's notes, and you look at the codex that the nurse is using, and you realize the differences that are there. Totally different notes and timelines that are there. And sometimes, you know, in the morning where the nurse will, you know, hand over for another, will say the patient was stable, and then the next, the doctor say that comes in and say the patient was gasping and all that. But these are important. I want us guys, when we focus on ethics again, we have to look at the records, and records are very important, a part of, you know, of ethics and governance, and how we execute health, and how we execute our profession within the greater scheme of things. Then the medical malpractice, you know, one of the most important, and this is one of the biggest challenges in this century that we have as medical practitioners. And you see quite a lot of cases that are, you know, increasing number of cases, and they're increasing also in quantum, in terms of, especially of civil claims that you have. There's almost a 10 to 14% increase on the quantum of the claims that are happening. And that is one of the biggest challenges we have. And if we have these big challenges in terms of the quantum claims and other stuff of the claims or numbers of claims that we have, it threatens our sustainability. It threatens our delivery of the system. And again, it goes back to that foundation of the beneficiation of patients. And it impacts on that at the end of the day. But again, let's go to medical malpractice. And I've discussed, you know, HPCSA and the Standard Health Professional Standard Committee can address issues of ethics, professional conduct. And professional conduct is one of the most frequent cases that are encountered. And again, it's important. What is unprofessional conduct, you know? And, you know, in the act, they just state it very clear. The competence in defining that is left to the Health Professional Council and the board to define it. It means also, is it an improper, you know, improper conduct one can have as a medical doctor, a nurse, or a health professional? Or is it, you know, disgraceful conduct? There's a lot of people, all the colleagues with disgraceful conduct. or is as a dishonorable behavior that one can have is very important that, you know, we should not forget that we can encounter in our practices. And it's very, very important that we realize that. And again, on the medical malpractice, most of the approaches that is there, if you have that, obviously there will be, you know, a harm, there will be, you know, an action or an omission. Remember, it doesn't have to be an action. It might be an omission. You neglected to do something that led to the patient, you know, having these consequences, or, you know, having the complication. And it's very, very important to realize that. And the approach that, you know, the courts are, you know, or the legal system in terms of this practice is more of a delictual thing. And the elements of delictual claim is again an action or an omission. There should be obviously somebody who claims that, and there's a harm, and again damages that are there. And then there should obviously be wrongful action or negligence, again, that I highlighted, that is very important. But again, when it's in contact with the patient, it is why it's important when you have a patient to talk to the patient, understand whether he understands what procedure you're about to do, and then the patient should reconcile himself to the complication that might arise, because you can plan for a certain surgical you know, procedure, but you might end up doing additional. It is very, very important to have that autonomy that we discussed. That also, you know, goes back to the umbrella of the constitutional the Constitution of the Republic of South Africa. Is very, very important. And our medical negligence, again, when you look at it medically, the standard use is of a reasonable medical practice. And there's been quite a lot of challenges. What is a reasonable medical practitioner? You know, in medicine, we've got surgeons, we've got cardiologists, and all these cardiologists, they've got different level of experience that they have. Cardiologists, we've got further even division of subspecialties that are there. But again, the standard that is used in the legal system to hold the medical practitioner, the medical profession, is a standard of a reasonable practitioner. Let me say a reasonable practitioner, but again, it's a standard of a reasonable medical practice. The test remains always whether practitioner exercise a reasonable skill and care, not exceptional or the highest skill or care. A reasonable skill and care of a practitioner in his or her own situation of position, or whether if the conduct fell below the standard of a reasonable, competent practitioner in his field, then there's a problem. And then I just highlighted one of the case laws of 1993, Castello versus Jeffrey. It's very, very important. Again, you are held against the standard of a reasonable medical practice. That's your peer, and in the situation, in your situation. And again, whether the exercise, what you exercise reasonable skill and care of that practice is very, very. If you fall below, therefore, then you are guilty for that kind of thing. It's very, very important to mention that because our colleagues are being engaged on that. And this is not just a substantive. You only get it during when you adduce evidence during the trial. It's very, very important because obviously then you will go through the hearing, or you go through the trial, and those are the facts that will be adduced, and the judicial officer will reach a conclusion whether you exercise a reasonable care, reasonable skill and care, or you fall below the standard and hold you accountable to that. It's very, very important. And medical malpractice is, there's other specialties that are very prone. I know insurances, what they pay to the insurance is a little bit high because of the nature of it. I mean, as we have it, the obstetrics and gynaes and the neurosurgical procedures are still leading, when in terms of the quantums and also in terms of the volumes, the number of cases that we have. But again, colleagues, I want us to look at this, because when we are we attend patients. We don't attend the patients in vacuum. We attend the patients in an environment that are very important, such as in the public health services. And again, you know, I've seen a lot of junior doctors who are not provided with adequate, you know, environment together with instruments that can help them in that. And in that process, what happens again? Then you will be charged with negligence because there will be some omission of some of the tests or tools that were not available in the particular. And then again, are we saying that we are going to be taking the responsibility? What about the public health sector? What about the private institution that, you know, in an emergency, they didn't have the tool that was critical in your approach to that particular patient? It's very, very important, again, not to say, to only look at a reasonable doctor. What about the situation? What about the environment in which that doctor has treated the patient? Because that is very, very fundamental, irrespective also of the skill. And again, it's important that, you know, you are compared to your peer at your level, not you know, envisaging the highest level that you know you should achieve. It's very, very important. This is the last slide. Why I put it this, I put it, you know, it as a health risk approach that, you know, one can have, whether it's at a very granular in terms of the patients or at a very strategic level that is there. Every patient, when you know, you approach the patient, especially surgical, those who go, obviously you have to assess the risk, you know, in comparison with the procedure, what you want to do, and also the envisaged outcome in terms of what you are going to do to the patient. Obviously, I'll take you, for instance, an example of an anesthetist. The approach is the risk. When you do those bloods, you assess, you know, the risk of the patient undergoing that procedure, and then also that will ultimately lead you to the outcome that one can have. It's very, very important for one to understand that risk model. But again, before we approach this, the patient that we have, then it is very important for us to realize that in every situation or environment, we've got controls that are in place. The controls that we have colleagues that will helping us, or the colleagues who are members of the team. We've got a hospital that is you know, equipped to the level that is acceptable. And these are very important. You've got even administrative support that is very, very important, so that, you know, the right patient reach you know, the theater and the procedure is done. But those controls are very important. There are ones that are preventive in nature. Preventative. It's very, very important that, you know, you look at them, you evaluate them, you relook at them, and you audit them, and to check whether, you know, those controls are still effective and efficient, so that, you know, when you do the procedure or attend to a patient or do a major operation, then you can limit the consequences, the risk, you know, that to the patient is very, very important. It happens, you can use this approach when it comes to theater. Then you've got the corrective control. Corrective controls, in case that we don't have this blood, we don't have the laboratory, and then you have the emergency that is there. A doctor at that moment, based on the knowledge, the examination, and other, you know, factors that are very important, will have to make a decision to say that the first preventing, the system has let me down here, then I'm going to approach it in a corrective. The corrective, you keep in mind that already, you know, the risk is amplified, and it's very important for us to realize that. And I would like to, you know, to thank you, colleagues. I think it was my last slide. And then if there's any questions, we can engage, especially at a very granular level. Thank you. Kamo?
Thank you very much, Dr. Mphofu. Quite a detailed presentation. I think you've given us an overview of the Health Professions Council as it operates, and I think taking us through all the sections of the council, and also what are the areas that we should be aware of to avoid trouble as practitioners. And thank you very much for this detailed presentation. Before I go to the questions, there are two questions about negligence and malpractice that I want you to refer to. But there's an area of education and training that you referred to, that it is one of the primary goals of the Medical and Dental Board. Just want to check with you, because there has been some, within the medical fraternity, colleagues over the last few years, and I think in the last year or and a half, the Medical and Dental Board has actually taken a decision to review or make a move towards moving away from having a single exit examination. There's some colleagues who are arguing that the council has abrogated its role as the custodian of training in the medical training for students, and that this power or this role has been given illegally to the Council of Medical, the College of Medicine of South Africa. Your view on that? I know it might be an unfair question, but I just want to keep, because it's a matter that is topical.
Yes.
And if there are any other colleagues who want to talk about that.
Yes. My approach is that what is coded in terms of the law is very clear. The competency and then the legislative body that is accountable and also responsible for the training and all those things is the health professional council, especially the boards, because if you look at the general powers of the boards in terms of that section 15, especially 1 and 2, is very explicit. It says that the board are responsible and accountable for that. And I would like to, and again, why I emphasize that, Dr. Bila, it looks, when you look at the way the act is couched, the Health Professions Council and the board appears to me to be a creature of statute. It's almost like your Majesty's court. You are dictated. You can have flexibility creating the committees, but when it comes to the ultimate, your responsibility and accountability, it's very important for one to realize that the accounting body is the Health Professional Council and the board.
That is my connection. You can hear me for the time being, but I can't hear you until I connect to my other device.
Okay.
But you go ahead. I'm not sure if you've finished talking,
yes.
Dr. Mphofu. On my other device, I'm struggling to hear. Yes. I'm still reconnecting on my other device.
Okay, yes. And it says you are responsible for education, training, and also at a very granular level, examination, so what is that, providing certificate. And that competency, when you look at it legalistic, is the competence of the HPCC. But the HPCC can maybe use the college, accredit it, but at the end of the day, the competent body that is responsible for the education and training is the HPCC. Let me just put it in a generic, that is the council with their board. And one thing I want to mention, in terms of Section 5 of the Health Profession Act, you look at the composition, it provides for the composition. And in that composition, that when you look at it, it's one member that will be appointed by the minister with the competence of the law. You've got the defense, you've got education, that is, you look at the board, and then you look at the vice chancellors, that is the vice chancellors of the university, that is very, very important. That is the composition. Why I stress it is because, again, when you look at the accountability in terms of those of the board and the council as established, it's very clear, guiding the profession. How do you guide them? Then you guide them through education, training, and all those things. And while by doing that, at the end of the day, you protect the society. That protection of the society still reside with the council and the board. Thank you. Dr. Bila, can you unmute? Kamu?
So I was muted. So
Yeah, yes.
okay, I was muted. Can you hear me now?
I can hear you, Doc.
Okay, thank you very much. Okay, there's a question here that says for medical malpractice, there has to be a proven intentional and lawful conduct as well as negligent behavior. That is the reason so few malpractice cases will be in court, but most of them are negligence cases.
Yes.
But then somebody said, now the question is, I'll come back to the other question that we've just seen here. It says now, if there's a wrong kidney that is removed, will that be malpractice or negligence?
When is there wrong?
If you take a patient to theater, you say you're going to be doing a renal transplant. There's one patient on the table that is donor and the recipient, and then you remove the wrong kidney. Or for some reason, there's one kidney that is cancerous, the other one is not, and then you end up removing the wrong kidney. Is that malpractice or negligence?
It's a negligence, and also it's part of malpractice. There was negligence. Remember, there was no intention. I assume you can't prove that burden when it comes to intentional, but there was negligence in removing the wrong one. Because again, this is why I'm saying that this case should not be treated in isolation from the environment, because if your systems controls are very robust in terms of preventing such things, therefore it will be picked up, whether in the nursing system or in the doctor system. But again, at the end of the day, if the wrong kidney is removed, then it was negligence, because negligence, how you determine it also is that the systems were not look at and the robustness and to pick up that you negligently remove the wrong kidney, but it was not their intention. Yeah. Anyway, every doctor who goes to theater, his intention
I think definitely it means that yeah. As you say, the processes are not followed. I think there are policies or even SOPs, and I think there's a clearly defined way of how to manage a patient going to theater from the wards. When you get to the theater, when the patient is received, and then also when the patient is put on the table, and then the requirements for the anesthetist, the surgeon, the scrub system, the anesthetic nurse, that should be to make sure that you're operating on the right limb. And but if you're or organ, if this happens, it means that those guidelines were not followed completely.
Yeah.
There's a question from a former colleague. we both had the enviable task of sitting on that chair in the Health Professions Council. Dr. Pinkwani wants to say, what is your take on medical practitioners being arrested by the police for incidents that occur while they're performing their official duties as doctors? We've had cases. I mean, there's a recent, I think they also immediately passed the case of Professor Bill and the unfortunate Dr. Munshi, who was killed about 2-3 years back. And what's your take on that?
My take on that is because that was a criminal case, the state uses the doctor. But again, my approach is that no doctor or a professor or a nurse goes with the intention to cause harm, and then it might happen negligently. But if the assertion is that the doctor who goes there intentional, because a criminal case usually has an intention, or it might also have negligence in terms of homicide, and this led to this. But my take is that doctors should not be arrested. First, there should be a detailed investigation before, and again, this should be done in sync with what is happening in the Health Professional Council, because they've got also the mechanisms that are there. Remember, the ones of health professionals on the balance of probability might be civil. The criminal one, unless the facts or the facts on the case is very granular with other transgressions that are extraneous to the process that we have.
Thank you very much. There's another question. Can the treating specialist refuse to provide the patient or the responsible GP with a written medical report and demand to be paid in order to provide such a report?
Yes, and this is one of the areas that is a very mined area when it comes to providing reports, and especially in the occupational health setup. And my experience, I know we have encountered such a thing. But remember, the report belongs to the patient. Again, who's the subject? The whole subject that we have is the patient. And if the patient demands that the report should be sent to the doctor, or through the patient or through the doctors talking to themselves, I think it's prudent to supply the report. But again, there's a little bit of confusion and also complexities that are there. I know some other doctors will demand a very exorbitant money in order to create those reports, which is fair to some extent. And again, it's very, very important. This is why when the HPCSA through Rule 23 and 27, the emphasis again is on, in terms of managing the patient, you don't have to only talk about the medical outcomes. You also have to include the fees, the finances that because it's very, very central. Ultimately, it will also influence the outcome. My take is that they should provide, and again, we've got duties to the colleagues. There's one slide that was there. We've got duty to our colleagues. And again, we have to work in harmony to provide that service that has a very significant outcome to the patient. I'm just mentioning these two things that we should not forget, especially the duty to our colleagues. Okay. Yeah,
definitely. I was going to mention that we have a duty to our colleagues, and I think you touched on that quite early on. That every healthcare practitioner has a duty to the colleague and the duty to the patient, which you said it's a primary duty that we have.
Yeah.
I don't see any further questions from the colleagues. Perhaps if you can just, if you're parting short, what do you want to be a message that colleagues can take home from this discussion that we had this evening?
Yeah. Colleagues, my take on this is that what we are facing in front is still is significant. But again, it will depend on our approach. When it comes to issues like that has an impact on the outcome of our patient ultimately. And then it's important that we should, I think, provide some, not education, what do you call it, learning, and we have to socialize ourselves with the new development and the fast changing pace of the world. And it's important again to go back to our ethics and look at them and say, look at the ones that are fundamental and where they are applied on a daily basis, and make sure that we practice. And let's put procedures in place or control systems in place wherever you work, whether you work as a private person, whether you work in a hospital. It's very, very important for us to establish those things. Thank you.
Yeah, before you part, I thought we took the last word. Brenda Libita's hand was up. I don't know if you still have, you want to ask a question, Brenda. And just Brenda prepares to ask that question. There's the follow-up from Moranadinso. This is, I think, you're challenging us on this discussion that we had. There's a legal duty to the patients. Now the question is, what legal duty, what legal framework informs that primary duty to provide medical reports? What is the legal framework for saying that you have got a duty to provide medical reports, one, to the patient, and two, to the referring GP?
Yes. One of the things that we have, Dr. Bile, is that when we treat the patient, it's not about treatment only. We manage the patient. And in the process of managing the patient, you've got procedures and you've got processes that one can follow. And again, one of the things that we tend to focus on and forget, it's about, you know, we treat the patient and say we stop here. You don't stop when that relationship with the autonomy of the patient, when you start it sustains itself for a significant time. And therefore, providing reports, again, is part of the outcome, because, you know, it cannot only be medical treatment that is there. Providing report is part and parcel of the, you know, whole system that is designed, and the outcome. We're looking at the output in terms of process, hardcore process of treating patient from patient doctor.
Yeah. No, thank you very much, Doc. I'm not sure if you have CPS. I can, yeah. No, thank you very much. I don't know if there are any. I see Brenda, your hand was up. Do you still want to say something?
Can I? Hello, good evening, doctor.
Good evening.
Thank you very much. I also want to find out from you in terms of, for example, there's 4 parties involved. You'll find that maybe we are the service provider, and there's our main client that we have the contract with, and there is the other party that has been contracted by the main client and the patient. For example, when this person was declared, or the person was fit for duty according to our records, but we are not the ones that has to disclose that information because we are down there, we have just rendered the service. And here the client comes to us directly to say, I demand my medical records because I've been seen by you. And here we would say, but we are not the main contractor. We don't have an agreement with you directly. We have been appointed by a service provider who has the contract with a, you know, for example, let me just put it straight. Maybe we'll down there we are doing the medicals. There's maybe our main contractor, and that main contractor has maybe been appointed by your subs or your government section. And here's the patient. Now, maybe the government section is supposed to appoint that person, but now they have their own, as you know, they have their own, should I say, corruption issues inside. And here this person knows for a fact, but the sister was saying, I'm fit, there was no problems with me. But now they have been told by the department, no, they have not been taken because there's issues. You know, they build up their own fake stories. And here the patient would come then directly to us and say, but I need to see my records. And then we say, but we don't have an agreement with you. We have been appointed by our own service provider or our own contractor and not you. How do you handle those things in? Because there's a shift of responsibilities, and you are then left down there and you have just offered the service, but we have a binding contract with our service provider. But now the patient doesn't understand that, and they would come to you directly because the government or the government department tries to run away from, you know, giving that information. How do you handle those things? But I don't know if I...
Yes, Brenda. One of the biggest things I always that.
Yes, Dr. Mphofu, I was battling with my. Are you able to respond to that question for Brenda?
Yes, I'll respond in nutshell. It might not be satisfactory.
Dr. Mphofu?
Yeah. Can you hear me?
Okay, go ahead. Yeah, I can hear you, but yeah.
Yes. Then in that delicate relationship that you have, you know, I always say people should fall back to the ethics and, you know, the profession that governs, that is governed by the HPCSA, what is provided for you. But again, I want to emphasize the content of the file belongs to the patient. Remember, that information is the patient's information. You know, and the physical part of the file, what is that, can be, you know, kept maybe it's the company for 40 years or the, you know, the service provider. But as far as the content is concerned, it's the patient. That is why I remember I had a little bit of a discussion with somebody calling patients and clients. You know, and fundamentally, when you look at especially the provision of the HPCSA, it's very, very important that you've got an ethical duty. It's a contract, but that is a special kind of contract. But now, in a contractual environment where you have a client, again, I would resolve to go into saying that to the point that the content of the file, that is the information, belongs to the patient.
Definitely.
Yes.
Okay.
Thank you. I just want, I know it's not satisfactory, but I just want to emphasize that. And then we've got quite a lot of contracts that are revolving around. But again, at the center is the patient. And therefore, the content, that information is very fundamental because it belongs to the patient.
Yes. Okay, thank you very much. I think we've run out of time.
Yes.
And I see quite a number of people are exiting, so we do not want to end up being the only ones here.
Okay. Yes.
Yeah, Dr. Pinkwan is asking us if you're going to share the presentation. I think normally the discussion is on YouTube and it's easy to access it. But the presentation, are you going to be able to share it with us? Then we can share it with the rest of the colleagues.
Yes, I'll send it, Dr. Bila.
Yeah, no, thank you. I can send it too.
Okay.
Okay, thank you very much.
Okay.
No, thank you very much, Dr. Mphofu. Robert, we had a great time with you, and it has been quite an eye-opening discussion. I think a good overview of how the Health Professions Council of South Africa operates, and a good interaction. I think colleagues are quite interested, and as I indicated, quite a high number of colleagues who logged in tonight. Shows that there's a lot of interest in this discussion. The third time that it's discussing something related to the Health Professions Council and other councils this year. But it shows the interest is still there. So just want to thank you for taking your time to be with us this evening, and to thank all colleagues who were here this evening who joined us. We quite appreciate your attendance every week, that you're always looking in to listen to the various speakers that are joining us every week. And so we just want to say thank you, and please keep on checking us every week, and like us on YouTube so that you can get previous presentations. And also to thank Clinics Health Group for availing this opportunity to us so that we can be able to keep the public informed, the medical profession informed, and that we can participate in also being there for the healthcare professionals across the spectrum, all the disciplines within our country. And thanks to government, the marketing team for the support for being provided every week to making sure that we have these presentations. And it's all for me to say, I wish you a good evening. Thanks, colleagues.
Thank you.